Hello, everyone, and welcome to the Immigration Brief. My name is David, and I'm a partner in the Los Angeles offices of WR Immigration. And I'm joined, as always, by my partner Naveen from our New York office. Hi, Naveen. How are you?
I'm well, thanks. Great to see you, David.
Great to see you. Today, we are covering a topic that is sometimes overlooked and not well understood by mobility and HR managers. And that topic is what we call CSPA, or the Child Status Protection Act. Nabeen, you want to talk a little bit about what that is?
Sure. So the Child Status Protection Act was enacted back in 2002. So it's been over 23 years now that it's been in play. And the whole idea is that because a child ages out when they're 21, to try and keep them under the age of 21 so that they're able to continue through the green card process with their parents. So that's the overall framework of the Child Status Protection Act. So when we see immigration processes taking so long, especially for certain country nationals, it is very likely that their child is going to hit 21, by the time they're able to complete the process. So we always want to make sure that, if possible, to have them benefit from CSPA, the Child Status Protection Act, then we are doing that analysis and everything possible to lock in that child's age. So let's talk about, who are the different people that are covered and perhaps how they're covered.
So I think there's this general understanding in the general public that someone ages out when they're 21. And so what children are covered even though they turn 21. So it's theoretically possible that derivative beneficiaries of asylum and refugee cases could be covered under CISPA, even though they turn 21. Children of U.S. citizens, children of lawful permanent residents, green card holders, and derivatives in family and employment based petitions, which in our practice, those derivatives in the employment based cases is really the most important thing. And so what we're going to do is today take a little bit of a deep dive in trying to understand and explain how that age is calculated. Naveed, you want to dive into the formula?
Sure. So the basic formula is, first of all, to understand the visa bulletin, which there's a recognition that there are quotas for green card numbers or immigrant visa numbers. And not everyone is eligible to obtain an immigrant visa number immediately, right? And so within the visa bulletin, every month, the State Department releases a publication which says, these are the different preference categories under employment and family and diversity visa, and for this month, these folks can either apply for the process to start that green card process, or they can actually receive an immigrant visa number. And so, because there is this delay, the way the CISPA works is that you have to see when does a person become eligible to obtain that immigrant visa number, and then how long was that person's underlying petition pending. So, and for employment-based cases, we're talking just about the I-140, recognizing that although somebody's priority date, which is their place in line for the visa bulletin, may be established from when the labor certification was filed, and the labor certification can take, 15 months. However, the period of time that we can only count is for the time that the I-140, which is stage 2 of a three-step green card process, how long that I-140 was actually pending. So when a visa number becomes available, subtract the number of days the actual petition was pending from the child's age. So let me just rephrase that. You have to look at the child's age when the visa number becomes available and subtract the number of days the underlying petition was pending. And then if that takes the person below the age of 21, then they should be covered under CISPA, but it's only locked in if they take certain steps to actually apply for that green card.
Okay, so if we break this down into a hypothetical, Naveen, if
Yep.
there's a family and they have a child, and the child is 21 years and 6 months when finally the I-140 is approved and they're current on the visa bulletin. And if for some reason, if the I-140 wasn't premium processed, I-140 took 8 months or 12 months to be approved, let's say it took 12 months, then according to CISPA, the person's age would not be 21 in 6 months. It would be 20 in 6 months because they were able to essentially roll back the clock by 12 months. And now the child's age is locked at 20 and 6 months, and they would be deemed to be a child according to immigration law, and they would be eligible to file for adjustment of status.
Correct, and even though the adjustment of status may take another 2 years to complete, for example, they're still locked in CISPA time, which would keep them at the age of 20. And you raise a really great point, David, because sometimes, although people want to rush through their green card process with premium processing, it may be in this situation better to not do premium processing so that the I-140 stays pending longer so that you are able to reduce the child's age more than just a few
Definitely.
weeks.
Yeah, sometimes there's some strategic ways to slow down the process. And when you have a child who is getting close to 21, those are some strategies that we look at sometimes. Definitely.
And then let's talk about what does it mean to seek to acquire. So, if the child is in the United States, they will file for adjustment of status with their parent. But what if the parent is in the United States but the child is abroad?
In that case, the parent can protect the child under CISPA by filing Form I-824, which is a form that is filed to really start the immigration process for someone who is not in the United States. And so that's really important. That needs to happen within 1 year of eligibility to lock in the child's date under CISPA. So you want to look out for that and not miss that key step. Naveen, do you want to talk about some of the recent policy changes?
Sure. So when we were talking about the visa bulletin and what I refer to as Chart A and Chart B, which is a final date of action and then the date for filing, historically, the State Department only had Chart A, which was the date when a visa number becomes available. And then a few years ago, they shifted into these two separate charts. And that created a little bit of a confusion because Chart B, the date of filing chart, enable people to apply for adjustment of status, for example, even though a visa number may not be immediately available to them. And so it does give you the ability to file that adjustment. And sometimes, it can be a significant jump in your ability to file earlier. But whether or not filing based on Chart B preserves and locks in the child's age under CISPA has been what's, I guess, under discussion, right? And then most
Yeah.
recently, USCIS announced that with this new policy, they will only look at Chart A, the final action date chart, to determine when the child's CISPA date is locked in.
Yeah, starting in February of 2023, the USCIS said that they would accept filings that were current under Chart B, but the Department of State had a different way of looking at it, and they continued only to accept cases that were current under Chart A. So it was confusing. And as of August 15th, the USCIS policy will align with the Department of State's policy, and they will only look at Chart A. But I think this is going to bring some really confusing situations. And I've had some clients that were really, really confused because there are scenarios where a family can file adjustment of status under Chart B. However, the child is not necessarily protected under CISPA. And so there's a scenario that's possible where family could file adjustment of status under Chart B and perhaps even get to an adjustment of status interview where the parents are approved and the child is not approved. And so that could be pretty devastating, especially if the family is not aware of it. So I think it's very important to not get complacent and to really look at this issue, even though these families might be able to file their adjustment of status.
And let's also talk about what it means for the child's non-immigrant status. So we discussed their ability to apply for adjustment of status, but a CISPA age doesn't lock in non-immigrant status, right? So,
No.
you have somebody here on H4 as a child of an H-1B visa holder. When their child is going to be turning 21, what happens to the H-4 status?
Yeah, obviously, H4 status goes away. And I think the important thing that we can take away from our current political situation is that, it's not good to simply have an adjustment of status pending with no underlying immigration or non immigrant status, if it's at all possible. So, many people who are aging out of H4s are at the age that they're going to be attending university. And so they will get into F1 status, so they will have an underlying status while the adjustment is pending. And that's certainly preferable to having no status at all, especially if there's any chance that the adjustment could be denied.
And then, being on F1 will give them the benefit of post-graduation OPT and potential STEM OPT. So that would be a way for them to go down that non-immigrant, journey of the F1 to, OPT to potentially their own H1 if this process will take a long
Absolutely.
time. But if you also had applied for adjustment of status, are you able to change status or acquire F1 status?
That's a good question. I would rather have someone preemptively get into F1 status before they file their adjustment of status. I think it would be pretty tricky to file change from H4 to F1 while somebody's already pending adjustment. What do you think, Naveen? Have you ever seen that work?
I think there's a lot of risk to that. So certainly because the F1 visa requires that person cannot have the desire to live in the US permanently, having an adjustment of status application directly contradicts that intent. So if at all possible, acquire F1 status first before even thinking about, applying for adjustment of status.
Definitely. So it's another example of where planning and strategy and looking forward is really important because, if you find yourself with a child who has an H4 trying to get into F1 status, that would be pretty difficult if the adjustment is already pending.
Yeah. So, David, let's talk about another wrinkle in this whole CISPA calculation. What if the parent files for naturalization and becomes a U.S. citizen through this process? So, um, let's talk about the family based schemes, right? Where the parent who's a permanent resident files an I-130 for their child who's still under the age of 21 and considered a child. So, what happens when the parent becomes a citizen?
Yeah, so you would think it would be beneficial. The parent files a family-based petition for a child, family preference petition. It's pending. Then the parent becomes eligible to file for naturalization. The parent naturalizes, and then unfortunately, the CISPA protection that the child had under the family preference petition goes away. And so, if the child is over 21 according to their calendar date, then they will lose that protection. And so again, another area where you want to look ahead and plan, and because sometimes something is that would seem like a no-brainer like naturalization could cause problems.
Right. And then other definitions that affect children is, whether or not that person is married or unmarried. If you have, a child who got married really young, right? Then, if and then they become unmarried, then it's possible that they may become considered a child again.
Yeah,
So, that could affect whether or not they are suddenly then classified as an immediate relative.
very good point.
And then let's talk about, extraordinary circumstances and what if you missed your window to seek to acquire the green card.
Definitely, that does happen sometimes because these applications are, they're pending for a long time, and sometimes the priority date becomes current and people miss it. And the law does allow for a second chance sometimes if you can show that there were extraordinary circumstances that were beyond your control and that were understandable. And one of those might be that, let's say someone is very ill and they're not able to pursue their application, or maybe they had ineffective assistance of counsel. And there are many, many other factual situations that might be considered. And so if you do find yourself in a situation where you missed the window and the child might be losing this huge benefit, there's really no harm to trying to argue that there are extraordinary circumstances. And then, of course, the government will make the ultimate decision.
Right. And what does it mean for visa retrogression?
Yeah, retrogression. Are you talking about in relation to extraordinary circumstances?
So extraordinary circumstances, or even if you were paying attention to the visa bulletin and filing on time, and then what is visa retrogression? How does that affect somebody's pending adjustment of status and CISPA protection?
So let's talk through a hypothetical again. A family finds themselves current under Chart A. Um, they file for adjustment of status. In the meantime, the child keeps on aging, and now the child is 21, 22. Adjustment of status is not approved. And during that time, um, the visa bulletin retrogresses. Now they're not current anymore because they took the steps to file the adjustment of status when the visa bulletin was current. The child's date is locked in and the child's protected, even if there is subsequent retrogression. Is that your position, Naveen?
Yeah, absolutely. And then if you do miss your opportunity and it retrogresses, then certainly you're going to look out for your priority date to become current again, so that you are able to then file, because eventually, the cow it will move, but hopefully it happens while your child still benefits under CISPA.
Absolutely. I guess we have come to the end of our discussion about CISPA. And I think some of the takeaways are that employers and their employees need to watch the visa bulletin, make sure they know when they're current, watch out for that 1 year window, plan ahead, both in making sure that if child is going to be aging out, they look at filing perhaps for a change to up one so they can stay in non-immigrant status. So planning and timing are more important than ever in protecting the eligibility of children.
Certainly, and then for global mobility, programs where you're thinking about what should the corporate immigration policy be about starting a green card process for your employee, in addition to considering visa max outs. You should also consider the family and, are there sensitivities such as having children who are a bit older and they may, have this danger of aging out. So you want to be able to plan starting the process early enough so that the children can be locked in under CISPA.
That's a very good point. I think a good visa or immigration policy at a company is one that does have some flexibility for situations like this. That's a very good point, Naveen. Well, thank you everyone for joining us today. We're always happy to talk through specific cases or help employers navigate these complexities. Drop your questions in the comments or reach out directly, and stay tuned for more insights in our next session.
Thanks for joining us.